Justice Amy Coney Barrett had destroyed countless liberal legal arguments with her originalist expertise, but she had never faced a conservative challenger this dangerous. As Senator Ted Cruz outlined his constitutional theory, Barrett's dismissive interruptions filled the marble chamber. "Senator, your interpretation of the Constitution is more liberal activism than conservative originalism," she declared with devastating intellectual authority. But Cruz's next move would not only silence her attacks, it would expose divisions in conservative legal thinking that would shake the Supreme Court. If you want to see how a Harvard-trained senator exposed the Supreme Court's most conservative justice using constitutional arguments that changed American law forever, watch this entire story and don't forget to subscribe for more shocking confrontations that the legal establishment tried to cover up. The Supreme Court's East Conference Room buzzed with unprecedented tension that Friday afternoon in April 2026. The private meeting had been arranged to address growing concerns within conservative legal circles about constitutional interpretation, judicial philosophy, and the direction of originalist jurisprudence in an era of rapid social and technological change. Justice Amy Coney Barrett, at 54, had spent 6 years on the Supreme Court establishing herself as the intellectual leader of the court's conservative wing and the most articulate defender of originalist constitutional interpretation. Her legal opinions had consistently demonstrated masterful command of constitutional text, historical analysis, and judicial precedent, earning respect even from liberal legal scholars who disagreed with her conclusions that Barrett's approach to constitutional law was rooted in rigorous textual analysis and historical understanding of the Constitution's original public meaning at the time of ratification. Her judicial philosophy emphasized the importance of judges interpreting law rather than making policy, constraining judicial power within constitutional bounds, and maintaining democratic accountability through elected branches of government. Since joining the court, Barrett had authored several landmark opinions that had reshaped constitutional law in areas ranging from religious liberty to federal regulatory authority to criminal justice. Her intellectual rigor and principled consistency had made her the de facto spokesperson for conservative constitutional theory and the court's most influential voice on originalist interpretation. But Barrett's influence extended beyond the court itself. Her writings and speeches had shaped conservative legal education, influenced federal court appointments, and provided intellectual foundation for Republican political positions on constitutional issues. Legal scholars across the political spectrum recognize her as one of the most formidable constitutional minds of her generation. Senator Ted Cruz, at 56, represented a different tradition within conservative constitutional thought. The Texas Republican had built his political career on aggressive advocacy for constitutional principles, but his approach emphasized political confrontation and popular mobilization rather than judicial restraint and institutional deference. Cruz's background combined elite legal education with populist political instincts in ways that made him uniquely positioned to challenge established conservative legal thinking. His Harvard law degree and Supreme Court clerkship had provided him with technical expertise that matched Barrett's scholarly credentials, while his political experience had taught him to identify gaps between constitutional theory and practical governance. What made Cruz particularly dangerous as a constitutional critic was his ability to use originalist methodology to reach conclusions that challenged both liberal and conservative orthodoxies. His constitutional arguments often pushed originalist reasoning to logical extremes that exposed contradictions and limitations in mainstream conservative judicial philosophy. The meeting had been requested by Cruz after a series of Barrett opinions that he believed represented dangerous compromises of constitutional principle in favor of institutional stability and political acceptability. He had specifically challenged her approach to federal regulatory authority, executive power, and congressional oversight in ways that suggested fundamental disagreements about originalist methodology. The East Conference Room was traditionally reserved for private discussions among justices. But Barrett had agreed to the unusual meeting because she viewed Cruz's constitutional arguments as intellectually serious enough to warrant direct response, even though his political motivations made him a potentially dangerous interlocutor. Present at the meeting were several conservative legal scholars, federal judges, and constitutional law professors who had been invited to witness what many expected would be Barrett's systematic refutation of Cruz's more extreme constitutional positions. The audience represented the intellectual elite of conservative legal thought and included several potential future Supreme Court nominees. As Senator Cruz entered the conference room that afternoon, he carried himself with the confident intensity that had made him one of the most effective constitutional advocates in the Senate. His reputation for thorough preparation and aggressive questioning had made him respected even by political opponents who disliked his confrontational style. Barrett opened the meeting with the intellectual authority that had made her the court's leading conservative voice, expecting to quickly expose the political motivations behind Cruz's constitutional criticisms. Senator Cruz, I appreciate your request for this discussion, but I have to say that your recent criticisms of the court's originalist jurisprudence seem motivated more by political calculation than constitutional principle. Barrett began, her tone carrying the scholarly authority that had intimidated countless legal opponents. The opening was designed to establish Barrett's intellectual superiority while questioning Cruz's credibility as a serious constitutional thinker, positioning the meeting as an opportunity for her to educate a politician about genuine constitutional law. Cruz's response immediately signaled that this would not be a typical academic discussion, where Barrett could rely on her institutional authority and scholarly reputation to dominate the conversation. Justice Barrett, I would suggest that political calculation and constitutional principle are not mutually exclusive, and that your concern about my motivations avoids addressing the substance of my constitutional arguments, Cruz replied, his prosecutorial training evident in his direct challenge to Barrett's attempt to dismiss his position. The response demonstrated that Cruz was prepared to engage in serious constitutional analysis rather than simply defending his political positions, catching the attention of observers who had expected a more deferential approach to the sitting justice. Furthermore, Cruz continued, I believe that some of your recent opinions reflect a concerning pattern of moderating originalist principles to avoid political controversy, which ultimately undermines the intellectual integrity that originalism is supposed to provide. The accusation was serious and direct, suggesting that Barrett was compromising constitutional principle for institutional or political reasons. Barrett's expression showed that she had not expected such a frontal challenge to her judicial integrity. Barrett attempted to regain control through her typical scholarly approach, emphasizing technical legal analysis over political considerations. Senator Cruz, originalist interpretation requires careful analysis of constitutional text and historical understanding, not political preferences or desired policy outcomes. Cruz's response would begin his systematic challenge to Barrett's constitutional methodology and her claim to principled originalism. Justice Barrett, I absolutely agree about the importance of constitutional text and historical understanding, Cruz replied, producing a comprehensive constitutional brief that he had clearly prepared extensively, which is why I'd like to examine how your recent opinions in several key cases demonstrate departures from rigorous originalist analysis. He opened to detailed textual and historical analysis that immediately captured the attention of everyone in the room. Let's begin with your opinion in Federal Communications Commission v. Social Media Alliance, where you upheld federal regulatory authority over Internet platforms. The case reference was specific and technical, demonstrating that Cruz had prepared serious constitutional analysis rather than just political criticism. Your opinion relied heavily on 20th century precedents about federal commerce power, but the constitutional text and 18th century understanding of commerce provides a much more limited basis for federal regulation of communication platforms, Cruz continued, displaying historical evidence and founding-era sources. The historical analysis was sophisticated and challenged Barrett's use of precedent in ways that suggested her originalist methodology was inconsistent or incomplete. Barrett attempted to defend her reasoning through reference to established Supreme Court doctrine. Senator Cruz, constitutional interpretation must account for settled precedent and institutional stability, not just theoretical textual analysis. Cruz's response would expose the fundamental tension in Barrett's approach between originalist theory and practical judicial governance. Justice Barrett. That response proves exactly my point about compromising originalist principles for institutional considerations, Cruz replied with devastating precision. Either the Constitution's text and original meaning control judicial decisions, or precedent and institutional stability control judicial decisions. You can't claim to be an originalist while prioritizing precedent over constitutional text when it's politically convenient. The logical challenge was compelling and demonstrated that Cruz understood originalist methodology well enough to use it against Barrett's own judicial practices. Furthermore, Cruz continued, clicking to additional constitutional analysis. Your deference to precedent in cases involving federal regulatory authority directly contradicts your originalist approach in cases involving individual rights, suggesting that your constitutional interpretation is outcome-driven rather than methodology-driven. The comparison was damaging because it used Barrett's own opinions to demonstrate inconsistent application of originalist principles, suggesting that her judicial philosophy was less principled than she claimed. Barrett was beginning to realize that Cruz had prepared a comprehensive constitutional attack that challenged her intellectual consistency rather than just her political conclusions. Senator Cruz, judicial decision-making requires balancing multiple constitutional principles and practical considerations that pure textual analysis cannot resolve. Cruz's response would deliver his most devastating critique of Barrett's constitutional approach while demonstrating superior understanding of originalist theory. Justice Barrett. What you've just described is exactly the kind of judicial activism that originalism was designed to prevent, Cruz replied, his voice carrying the prosecutorial intensity that had made him famous. The moment judges start balancing constitutional principles and practical considerations, they're making policy choices rather than interpreting law. He clicked to quotes from Barrett's own academic writings before joining the court, where she had advocated for more rigorous originalist methodology. These are your own words about the importance of constraining judicial power through textual interpretation. Your current judicial practice contradicts your own constitutional theory. The evidence of intellectual inconsistency was compelling and suggested that Barrett's judicial philosophy had evolved in directions that compromised her originalist commitments. But here's what really concerns me about the direction of conservative constitutional law, Cruz continued, clicking to his most powerful analysis. Your approach to originalism has become a sophisticated form of conservative judicial activism that uses historical analysis to justify predetermined political outcomes rather than following constitutional text wherever it leads. The accusation was serious and challenged not just Barrett's specific decisions, but her claim to represent principled constitutional interpretation. Barrett attempted to defend her judicial approach through reference to her consistent conservative outcomes. Senator Cruz, my record on this court has consistently supported conservative constitutional principles and limited government. Cruz's response would expose the fundamental flaw in Barrett's defense and demonstrate his superior understanding of constitutional principle versus political outcome. Justice Barrett. That response confirms my critique, Cruz replied with devastating clarity. You're defending your judicial philosophy based on political outcomes rather than constitutional methodology. True originalism follows constitutional text, and original meaning regardless of whether the results are politically conservative or liberal. He produced examples of cases where rigorous originalist analysis might require outcomes that differed from conservative political preferences. A principled originalist should be willing to reach liberal conclusions when constitutional text and historical understanding require them, just as a principled originalist should reach conservative conclusions when the Constitution demands them. The intellectual challenge was profound and demonstrated that Cruz's constitutional criticism was based on deeper principles than Barrett's approach, even though both claimed to be originalists. The problem with your judicial philosophy, Cruz continued, is that it uses originalist methodology as a tool for reaching conservative outcomes, rather than as a constraint on judicial power that might sometimes require uncomfortable conclusions. Barrett was now facing a fundamental challenge to her intellectual integrity and constitutional methodology from someone who understood originalist theory better than she had anticipated. Senator Cruz. Originalist interpretation isn't a mechanical process that produces automatic results, Barrett replied, attempting to defend complexity in constitutional analysis. It requires judgment and wisdom in applying constitutional principles to modern circumstances. Cruz's final response would completely transform the meeting and leave Barrett without an effective defense of her constitutional approach. Justice Barrett. What you've just described is exactly the kind of judicial subjectivity that originalism was designed to eliminate, Cruz concluded with prosecutorial precision. The moment judges claim that constitutional interpretation requires their judgment and wisdom about modern circumstances, they're asserting exactly the kind of judicial supremacy that originalism rejects. He clicked to his comprehensive conclusion, showing systematic analysis of constitutional text, historical evidence, and logical application of originalist methodology. Constitutional interpretation should be constrained by text and original meaning precisely because it prevents judges from imposing their personal judgment and wisdom on democratic society. The intellectual argument was unassailable and positioned Cruz as defending more rigorous constitutional constraints than Barrett, despite her reputation as the court's leading originalist. A true originalist follows constitutional text and historical understanding even when it leads to results that conflict with their political preferences, institutional concerns, or personal judgment about wise policy. Cruz concluded, your judicial approach, while sophisticated and well-intentioned, ultimately substitutes judicial discretion for constitutional constraint. The critique was devastating and left Barrett without an effective response to Cruz's challenge of her constitutional methodology and intellectual consistency. The meeting concluded with Barrett acknowledging the seriousness of Cruz's constitutional analysis, while disagreeing with his conclusions about judicial methodology. But the intellectual damage was done, and several observers noted that Cruz had exposed significant weaknesses in Barrett's originalist approach. Within weeks, legal scholars were publishing analyses of the Cruz-Barrett exchange, with many conservative constitutional experts acknowledging that Cruz had identified legitimate problems with mainstream originalist jurisprudence and Barrett's judicial approach. The confrontation became a turning point in conservative constitutional thought, forcing serious examination of whether originalist methodology was being applied consistently or was being used to justify predetermined political outcomes. That Ted Cruz had not only challenged Coney Barrett's constitutional approach, but had demonstrated that rigorous constitutional analysis might require more intellectual honesty and political courage than even the court's most conservative justices were willing to provide. The meeting proved that authentic constitutional interpretation required following text and original meaning wherever they led, regardless of political convenience, institutional stability, or personal preferences about wise policy outcomes.